We'll be talking about judicial reform. What does the judicial reform entails? I would like to invite Oksana Syroyid, Deputy Speaker of Ukraine's Parliament, Romana Kuybida, Deputy Chairman of the Center for Political and Legal Reforms, judicial expert at the Reanimation Package of Reforms, and Valentyna, Simonenko, Head of the Council of Judges. Oksana, you're welcome. Good afternoon. Greetings to you. The primary reason why we came here was the opinion of Venice Commission to the law of Ukraine on ensuring the right for fair justice. Our initial idea was to present to you the main vision, the main ideas of the opinion, what was reflected or what was not reflected in the new law from the point of view of European experts, and to show where we can move forward. I believe that what we can state now is that the law on ensuring the right for fair justice opened up opportunities for changes in judicial system. What is the most important? It is for all the institutions on which the quality of judicial system depends should start working. And that is highest qualification commission, which is in place, but which requires, according to the law, more members. The highest council of justice, which is not operating for the whole year. The bodies of judicial self-governance and leadership of courts. And I would like to mention that we have the threat today that there will be attempts to slow down or to disrupt the work of these key institutions. There are grounds to believe that the Congress of the Lawyers, which has to appoint 3 members to the highest council of justice, will be disrupted, or something else will happen. And I believe that it is very important for the civil society, for the journalists to pay attention to that, and to follow that this process is taking place transparently. We cannot allow the judges not to be made responsible as the Ukrainian society expects. The second threat is introduced by the law, the opportunity for heads of courts to be elected for the term of 2 years. The trend may start, and there are suspicions about that the current heads of the courts, which were elected last year, now will be trying to be re-elected in accordance to that law, this way believing that their previous term is not included into the whole term. That is dangerous trend, because it will not restore the trust to the judicial system. If we see that the heads of courts who have to demonstrate that courts are moving forward, that courts are ready to be responsible, that courts are ready to change, that judges are ready eventually to satisfy the expectations of the society. If they slow down the process, if they demonstrate the opposite, then we'll be losing the trust to judicial system. Now, as to the opinion of the Venice Commission, I think it was well expected. All the criticisms there was well expected, because all this criticism is about the powers of the President and Verkhovna Rada as to the judicial career. That's the powers of the President to appoint, to dismiss judges, and so on, and also the powers of the Verkhovna Rada as to appointment of judges and dismissal of judges. these powers are stipulated by the Constitution, and unfortunately we cannot get rid of these factors. We can do that only if we introduce amendments to the Constitution, and I hope that all the participants of the constitutional process will understand it, and the constitutional dialogue will lead to the situation when we get rid of these political powers. And one more thing, we all should understand that that is just the beginning of the judicial reform. That's the beginning of a very long way. It will not be an easy one, because judicial reform will take place when in the courts or judges, or when new people will become judges. One or several generations have to change till we renew the judicial system completely. That doesn't mean that we shouldn't be doing anything now. We need to do some things quickly and consistently, introducing amendments to the legislation that regulates all the institutions. But we need to understand that the way is long, and the judicial reform will take place when the judicial community independently will recognize the responsibility for what was committed by the courts, even by judges that were there before them. Thank you.
Good morning. I'm Simonenko Valentyna. I'm head of the Council of Judges. First of all, I would like to describe more the Venice Commission opinion. I fully agree that judicial reform is on the right track, and it should develop in that direction which is suggested by the law, and here it should come closer and closer to the European standards. So the opinion of Venice Commission contains several items which I would like to describe. First of all, changes to judiciary reform is impossible without amendments to Constitution. This entails the impact of the president on the judges' careers, the scope of competences of the judges, the Supreme Judiciary Council should comprise more members. It should be united with the High Commission of Judges, and this is not the first time when Venice Commission points out to this shortcoming, and also the Commission criticized the assessment procedure for the judges, and pointed out that such assessments should be carried out by more experienced judges with involvement of international experts. Besides that, Venice Commission underscored that willing to deprive from positions corrupt judges should be done fairly and proportionally, without any negative implications for the judiciary system as a whole. And we fully agree that to do this, we should amend the Constitution and add some changes to this very law, which was analyzed by the Venice Commission. As for the renewal of the judges' membership. Judiciary community is absolutely interested in getting rid of those judges, notorious judges who demonstrated very negative behavior. These cases happened in Zhytomyr, Odessa, and some other places, and when there are criminal cases filed to court for positive decisions, for wrong decisions, and actually, and also there is pressure upon judges. So actually, these are two sides of the same coin. We should get rid of those judges who proved to be corrupt, who have no dignity and honor and integrity, and on the other hand, we have to protect those judges which make fair decisions, but those decisions are not liked by somebody. And the majority of judges agree with this opinion of the Venice Commission, and we are very eager to implement it. Good morning. The information space is full of discussions and debate about judicial reform. Yesterday, Venice Commission has passed the decision on the law, voted for its opinion, and tomorrow the law comes to force. Actually, this is only the first and small step towards a fair justice system. In general, we need to launch, to reload all the institutions necessary for full-fledged judicial reform. The High Commission of Judges. First of all, there is a huge social demand that those judges who acted upon their own discretion and unfair, that they should be punished. And I expect that this process, this initial process, might take up to 2 months, and also I expect that major oppression will be made by those judges who will try to hinder in many ways the work of newly elected members of the High Judiciary Council. Also, it is important to prevent that representatives of political forces would not occupy seats in the High Council of Justice. All the candidates are made public. This is a novelty which was introduced by the law. And now on the website you can see all the candidates nominated by the Congress of Advocates, the Congress of Academic Institutions, etc. Looking at the opinion of Venice Commission, at those 19 pages, you should notice that up to 8 times or even more, it points out to political threats, that is on the possibility of political influence on judiciary, which will distort its independence. I do not think that in nearest future major dismissals from judges' positions will be caused by their personal wish to leave the posts. I would advise that mass media should carefully follow the process, how the judges will be changed. If we do not prevent the possibility for political influence, political changes in the judges' corps, then the reform as a whole will fail. What we will do next? First of all, we will do our work on mistakes. We have realized that without changes to constitution, we will do nothing actually. We may pretend that we do something without changes to the constitution, but actually there will be no changes. In Yanukovych times, discussion about changes to constitution delayed the process for a long time, and nothing actually was done. That's why the process currently moves with the speed of a turtle, and when we speak much about the judges, the Constitutional Commission, we immediately understand that there have been a year when the commission was planned, but it is not appointed yet. Also, the application of changes will be seen immediately in the moment when judges will vote for the chairpersons in the courts, the collegium of judges in the courts. And if new people will come, we immediately will understand that changes have started, and if nothing changes, we immediately will understand that they try to preserve the system.
Your questions to our speakers, if you have any. Please introduce yourselves. Законный business. There was information that those judges who are working now, they cannot be elected. It was planned that they to write that they will be able to serve 2 terms, and also for example, such presidents of the courts will not have their certificate signed. So first, the law says that the judge cannot occupy the same administrative position twice in a run, one time only. And as to certificates of the presidents of courts, the certificate is to be signed by the president. That's one element which is in the new law. Even in the previous one, there was no such a norm. I believe this will be one of the ways to put obstacles to the work, but it is important that judges themselves should elect and should correctly interpret this law. I have a lot of this information that, like according to the previous law, the presidents of courts were elected by minority. The no one of the judges wants to make it public. And unfortunately, there were cases like that. So the public control, or there is a lot of attention to this process, and it should be in respect to every court. I would like to provide comments. There is information that because the new law becomes effective, and according to that, the head of the court could be elected for 2 years. Now some heads of the court, they write the application to be dismissed so that they can be elected as heads of judge of the courts for longer period, because now we have a new norm which is now in place, and that means that this person, it does not cover this person. If you remember the case of the Constitutional Court, it's about the third term of the President Kuchma. There was an argument that President Kuchma could be elected for the third term because the first time he was elected according to the previous constitution, and as the norms of the constitution changed, that president wasn't the president, and no one interprets it from the point of view why this norm is there. It's there so that the same person cannot occupy this position. So this is the preventer of corruption, and also the judges are to feel responsibility and should have access to this system of judicial self-governance. I absolutely agree with the motivation of limiting the term of staying at the position, but I wouldn't be talking about prohibition to have 2 terms. Let's look at Article 20. The judge elected to administrative position cannot hold this administrative position of this court for more than 2 terms in a run. But there might be some situations. At this stage, I wouldn't emphasize it that way. The question to Oksana Syroyid, as initiator of many laws in the parliament, we say that the judicial authorities are to be cleaned. Those judges who made resolutions related to Maidan should be punished. But we see that the new law does not protect judges from the pressure. There are many articles, 375 for example, but very often the prosecutor office starts persecution, violating the norms. The prosecutor's office passes the resolution on filing the criminal case. How should the judicial reform resolve that issue so that both sides do not accuse each other? One, as Platon said, you need 2 things only: good intentions and the reason. That is what is needed to reform as well. You understand that every time we are in the system of coordinates, when we are trying to address certain distortions that we create, we first created the corrupt system. We formed it because there was the law of 2010, and there were several norms developed so that they allowed to create the corrupt system. Then there was a law on restoring trust to judicial authorities, which had good intentions, but the norms were manipulated and they didn't work. Now there's law on ensuring the right for just court. We were working on that draft, preparing it for the second reading, and we succeeded in preserving certain things which are needed for reforming judicial system in this law. But again, for the legislative draft to foresee how every norm could be distorted is very difficult. If you look at the opinion of Venice Commission, they make remarks that the law is too detailed. Why is it too detailed? Because experts thinking about, they go from the opposite. Every time they think how this norm could be distorted, and they are trying to include all preventive mechanisms. And so all of us shouldn't be thinking about distortion, but we should think about how this should be applied fairly. As to the prosecutor's office, the prosecutor's office is part of the system which is corrupt. And unfortunately we failed to do what we had to do, to reappoint all the prosecutors, to reduce the third of them, to dismiss third of them and reappoint them, and to cancel the militarized system, because the prosecutor's office is still operating as a pyramid, but it should be like judicial system, horizontal. Every prosecutor has to be procedurally independent and be responsible as a judge. Our prosecutor office is still Soviet-type prosecutor's office, and I'm talking about understanding that by them their function. They are lazy, and they're used to whatever they write, the court will repeat, and based on that will make a sentence. They cannot execute the main function of the prosecution, collecting evidence and developing arguments. Because of that, when you saw the process of voting for giving the consent to the arrest of judges in Verkhovna Rada, that was an awful phenomenon. If you look at the conclusions of the prosecutor's office, they were far from being perfect. I made a comment that if prosecutor's office continues developing such opinions based on which the parliament has to vote, but the parliament has to vote if all the society knows that these judges were doing it, how not to issue the order for arrest. But I understand that based on such opinion, the judge, the court can pass the judge will demand that he is restored in his position. That is the responsible behavior of the prosecutor's office. Briefly.
Микола Болінський, Право ТВ. About Article 375, what are criteria which make sure that the decision is lawful, and what was the opinion of Venice Commission on this article? Maybe I will comment. You're right that there are no such criteria. What does the unlawful decision mean? And the Council of Judges also have not produced any explanation on this, and also the committee of the High Court have not provided its explanation yet. And actually, as of today, we have to answer this question whether the decision is lawful or unlawful based on our own discretion. And I would disagree that some good laws are subjectively applied wrongly. And yesterday I observed the application of the criminal cases and criminal justice, and I have noticed that in that's oblast, Tomer, Kherson, etc., where there were distortions in the fair justice and fair judicial process, there is a pressure upon judges. Of course, we will follow up such cases, and the lawful and unlawful decision could be judged from the exclusively from the principles of law exclusively. And here I might refer to Ms. Valentyna's article where she stated that unlawful court decision is always actually obvious. I would add, in normal country, such articles should not exist. But there are some abuses which require such article to be present in the law. For example, if there is the obvious case and no decision on the case. And quite often, even not going deep in the case, in the matter of case, it is quite obvious that the decision is unlawful. And of course, in each case, when such assessment about lawful and unlawful decision is made, this first assessment should not be final. Also, those judges who were appointed in result of the law or of clearing the judiciary, they were re-elected from the previous period, and the same judges, there is a threat that those judges might be elected based on the new law, saying that now they are elected based on the new law. Thank you very much for your information. Our next briefing will be in 2 minutes. Thank you.